Welcome to the training session by Pro-CS for SEBI Prohibition of Insider Trading Compliances. Today we will discuss the compliances mandated by Stock Exchange Board of India or SEBI to prevent the misuse of unpublished price-sensitive information by the promoters, directors and employees being insiders of the company for their own personal gains. This training is divided into the following given chapters and is aimed to provide awareness to insider laws and act a guide on the insider compliance requirements. Chapter 1. What is insider trading and how do you know if you are an insider? Insider trading is the illegal practice of trading in your company stocks to one's own advantage, by having access to confidential and unpublished price-sensitive information, UPSI. Insider trading is illegal because it gives the insider, better called as a designated person, an unfair advantage in the market, puts the interests of the insider above those to whom he or she owes a fiduciary duty, and allows an insider to artificially influence the value of the company's stock. Any employee is determined to be an insider or a designated person if they have access to any unpublished price-sensitive information, UPSI, regardless whether you trade in the stocks or not. Such people may include directors, promoters, key managerial persons or department heads. Designated persons are also required to declare any immediate relatives who also trade in the company shares. Such relatives may include any person who is dependent financially on such designated person. Consults the designated person in taking decisions relating to trading in securities. Also, as per SEBI compliances, if you are married, then inclusion of your spouse is mandatory. Chapter 2. What is unpublished price-sensitive information or UPSI? UPSI refers to any information related, directly or indirectly, to a company or its securities that is not generally available and which, upon becoming generally available, is likely to materially affect the price of the securities. So what information is considered as UPSI? If you are in possession of any information such as financial results, dividends, change in capital structure, mergers, demergers, acquisitions, delisting, disposals and expansion of business and such other transactions or changes in key managerial personnel, all these are considered as UPSI information. Also, the basic thumb rule for any information to deem it as UPSI is to ask if such information is likely to materially affect the price of the securities upon coming into the public domain. One important thing: as a designated person you are allowed to share UPSI only for legitimate purposes, for performance of your duties and discharge of any legal obligations. Also, please ensure that before sharing any UPSI information, with any third person, auditor or vendor outside your network, you have a proper binding non-disclosure agreement and that you have the name, official email and PAN details of the person with whom you are sharing the UPSI information with, as such may be utilized by compliance officer and is now a statutory compliance. Chapter 3. Disclosures to be provided by designated persons. As an insider you are required to submit disclosures regarding yourself and dependent relatives on annual or biannual basis dependent on your organization policy. For designated persons you need to provide details like PAN, address, phone number, educational institutions and details of past employers. Same goes for your dependent relatives as well. However, for relatives, if PAN is not available you can provide any other identification as authorized by law. Another disclosure as mandated by SEBI is for the material financial relations. If you provide any financial assistance to any immediate relative, which is equivalent or more than 25% of your annual income, then the declaration for that relative is required with PAN, and other details. Also, this information is to be declared for any transaction done in last 12 months. Additional declarations required from designated persons also include personal and relative details, demat account information for yourself and relatives, equity or holding in the company by yourself or by your relatives. As per SEBI guidelines, designated persons are mandated to provide initial disclosure in terms of Form B and Form K. Form B is to disclose the initial holding of designated person upon joining the company, while Form K is submitted annually and contains details of relatives, education details and work experience. In case the designated person trades in company shares in excess of 10 lakh rupees in a quarter, additional continuous declaration in Form C is required from designated persons providing details of trade made. Also, this Form C needs to be submitted to compliance officer within 2 working days of making such trade. Additionally, annual and biannual declarations in terms of Form F and Form E are required by SEBI from designated persons. These forms are submitted, with overall shares held before and after the financial year, and the number of shares bought or sold during the same period. Some companies also require biannual declaration Form E to be submitted by designated persons, every 6 months, to keep a track of shares bought or sold on a half-yearly basis. Chapter 4. Trading done by designated persons in company shares. Any designated person can trade in company shares through following methods. By subscribing to initial public offer or IPO, buying or selling of shares, dealing in open offer or buyback of shares and derivatives, agreeing to subscribe, buy, sell and deal of shares, pledging of shares, and through employee stock options. Now that you can trade in company shares, still there are some compliances we need to follow before making the trades. First, the trade can be only made when the trading window is open. By law, trade cannot be made by any designated person from the end of the quarter till 48 hours after the board meeting of the company or when the financial results are declared. This period is called as trading window closure. The trading window closure reminders are also sent by compliance officers to all the designated persons. Also, please remember that there are still some certain trades you can exercise even during the trading window closure. These may include allotment of ESOP shares, subscribing to rights issues, pledging of shares, etc. Before trading in shares, certain compliances are needed to be ensured by designated persons. If the trade is in excess of 10 lakh rupees within a quarter, pre-clearance is required from compliance officer to execute their trades. Forms G and H are required to be approved minimum 2 days in advance before making the required trade, which is provided via a pre-clearance order and is valid for maximum of 7 working days. After the trade, the designated person has to submit Form C and Form J to compliance officer. In case the trade is not made, then Form J is to be submitted without fail to compliance officer. Also, for purchase or allocation of shares under ESOP, approval is not required but same needs to be reported to compliance officer via Form C. Chapter 5. Contra trade and penalties for non-compliances. Contra trading means taking opposite position in trading of securities following a transaction. Even intra-day trade or buying or selling of shares on same day falls under the definition of contra trading. Designated persons or their dependent relatives can do opposite trades minimum 6 months after last transaction. So what are the penalties for non-compliances? Under Section 15G of SEBI Act, 1992, penalties can be of minimum 10 lakh rupees. It can extend to 3 times the profit made or 25 crore rupees, whichever is higher. In certain cases, such non-compliance actions can also lead to imprisonment. Companies can also lay heavy fines and disciplinary actions like suspension from job or termination along with the SEBI penalties. Final chapter. Summary of do's and don'ts for trading. First, please ensure to provide requisite disclosure for self and immediate relatives on timely basis and that the disclosures are true and fair. Ensure that trading window is open when you trade in company shares, even for your relatives. And finally, check the trading window closure intimations from compliance officer. For trading, you are required to obtain pre-clearance from compliance officer before trading above 10 lakh rupees in a quarter. Once approved, report trade done to compliance officer. In case trade is not executed, still report it. You should also be aware of the Insider Code of Conduct policy and adhere to the laws set by your company. Designated persons are also required to safeguard any UPSI they possess. Designated persons are advised to refrain from trade during trading window closure. Also, it's beneficial to avoid trade when in possession of any UPSI. You are also advised not to share any UPSI with family or friends and only share such information on a need-to-know basis and with proper agreements in place. Also, please don't make any contra trades or intraday trades in your company shares. Finally, in case of any UPSI information being shared with external members like vendors, auditors, and business associates, please mark a copy to your compliance officer. In Pro CS Insider Trading, you can mark a copy of UPSI emails to upsi.srl@rpsg.in. Thank you for attending this session and have a nice day.